My name is Junu. Today we are going to do a presentation on a case study of Whitehouse versus Carlton Hotel Pvt. Ltd. 1987 162 CLR 285. We are 5 members in the group and each of us will be contributing our ideas and thoughts in the presentation. I'm going to start with the introduction. Our presentation emphasizes on the facts of the case as well as on the breach of duties on the part of the directors. Mr. Charles McDonald's Whitehouse, which is also the governing director of Carlton Hotel, issues 3 different shares. Type A share. This share has unrestricted voting rights and were held by Mr. Whitehouse himself. Type B share. This share had partial or say conditional voting rights and were held by Mrs. Whitehouse. Part C share. These shares had no voting rights at all but carried rights to share in profits and surplus capital, and these shares were held by his sons and daughters. Now, after the divorce of Mr. and Mrs. Whitehouse, the daughters aligned with the mother and the sons were on father's side. To make sure the company is in trusted hands, speaking from Whitehouse's point of view, that the daughters or their husbands shall not be entitled to gain practical control over the assets of the company, future and at present other than the shares allocated to them. Now, after the death of Mr. Whitehouse, the Class B share owned by Mr. Whitehouse will exercise full voting rights given that there will be no change in company's capital. Therefore, to insert the balance, Mr. Whitehouse decided to purport the rights vested in Class B shares to his sons in order to dilute the voting rights so that company will not fall into the daughters or their future husbands' hands. Mr. Whitehouse was the governing director at the time he purported the share to his sons, and therefore it is argued that he had breached the duty of the director and the company policies while making this decision. Now my friend Sarmila will take over from here. Thank you.
Thank you, Zuno. Hi, it's Miss Sarmila. Now I am going to explain about breach of duties and responsibilities. The duty and responsibility that have been breached in the present case are concerned with the section 171 and 173 of the Company Act 2006 and also contained in the provisions of section 181 of the Corporation Act 2001. According to the provisions of section 171(1)(b, the power of the directors should be utilized for the benefit of the company and not for abusing beyond the constitutional limit of the company. Similarly, fiduciary duties of the director, section 173, explain that there is a duty on the part of the director to make autonomous use of their fiduciary duties without the influence of unlawful interest. Therefore, it is required for the directors to act in a way which would prove to the best for the company and its member and not for the interest offered to them by the third parties. Again, in the case of the Whitehouse versus Carlton Hotel Pvt. Ltd., it has been observed that Mr. Whitehouse has breached his duties and responsibilities as a director because it occurs to him that it would be appropriate to transfer for Class A share on his part of his deceased wife to his son. This was done by Mr. Whitehouse in order to ensure that his daughters do not claim their rights in the asset of the company. Now, my friend Chandika will take over from here. Thank you.
Thank you, Sarmila. Hello, I'm Chandika Shrestha. Now, I'm going to explain about the critical analysis of court decision of this case. It has been found by the trial judge after evaluating the evidences presented before it that the decision on the part of Mr. Whitehouse being the director has been made without good faith and for an improper purpose. The trial judge was opinion that though the decision on the part of Mr. Whitehouse was void, and in such cases the interests of the director of a company are protected by the rule of Indo management. However, it has been argued on a trial on the part of the defendant that the allotments of share were meant for the purpose of fulfilling one interest, therefore the decision was held to be invalid. According to the decision of the full court, it has held by the majority decision that the allotments of share can be considered to be void based on two reasons. First one, the company did not act according to the provision of Articles 59 of the Articles of Association of the company while making the allotments of shares. Secondly, the allotments were made with an intention of the improper purpose, thus the respondent did not accept the decision, and it has been argued on their part that Class B shares, which were previously allotted to Alexander, should have been allotted to the wife of Mr. Whitehouse, who was the shareholder of Class B shares. It is noteworthy to mention here that primary issues of the appeal is concerned with the fact that whether the allotment of share was issued for improper purpose. Therefore, it can be argued that the consideration regarding the issue must have been addressed with a general proposition. However, emphasis should have been laid upon the fact that the power exercised for the allotments of share is in fact a fiduciary duty which must be exercised by the director for the best interest of the company. Thank you. And now I'd like to hand over to my friend Deepali. Thank you.
Thank you, Chandika. I would like to talk on the relevance of the decision to the development of Australian corporation. There is a duty on the part of the directors to act bona fide, that is good faith. However, in some cases, when a person occupies the position of a director for a long time, then it's obvious that he might forget that a company possesses separate legal personality. It is evident that a company without its director cannot act its own or fulfill its legal responsibilities. Therefore, it's important on the part of the director to comply with the duties that have been assigned to him for the purpose of development of Australian corporation. According to the requirements of the principles of common law, a director must act in a good faith for the efficiency functioning of the affairs of the company. The decision of the director must be exercised in good faith for the best interest of the shareholder as well. The decision that has been held by the court regarding to the fact that whether the duty assigned to the directors are in the compliance with subjective test of honesty and good faith created forever impact upon the operations of Australian companies. In this regard, it is noteworthy to mention that the presence of absence of good faith on the part of the directors depends upon certain circumstances. It's worth noting that no uniform rule has been established so far for the purpose of evaluating whether there is a presence of good faith in those circumstances. Therefore, according to the decision, transaction entered on the part of the director on behalf of the company, which is outside the scope of the purpose in which company has been established, shall be considered to be the bad faith. In such cases, if the director of the Australian company consents to such contract knowingly, then it shall be considered as a bad faith. Now I would like to hand over to my friend Anup to conclude the presentation. Thank you.
Thank you, Deepali. I'm Anup, and now I'd like to present the conclusion regarding this case. Here, Mr. Whitehouse had all the shares and all the power. He decides to set up what happens when I die procedure. He has Class A shares, his wife has Class B shares, and kids have Class C shares. Alright, after he got divorced with his wife, he cooks up a scheme so that the boys get the shares so they can swamp everybody. The purpose in allotting the B class shares to his sons was to procure the dilution of the voting power, which might attach to Mr. Whitehouse shares on state, and to ensure that those whom he favored would then command the majority. The decision of the Mr. Whitehouse, according to his perception, was in favor of the company, and he believed that by manipulating the voting rights in favor of his sons at expense of his former wife was in interest of the company. Well, it can be felt that his decision was quite selfish, and of course he breached various duties and responsibilities as the director of the company, which includes breaching of section 171 and 173 of the Company Act 2006. Moreover, he was not acted on good faith and improper purpose under the provisions of section 181 of Corporation Act 2001. which was also discussed earlier by my friend Sarmila. Okay, afterwards, the court held that the test as to whether this duty has been complied with a subjective test of honesty or good faith. The presence or absence of good faith depends on the circumstances that are present in each case, which is why the court cannot pin it down precisely. To sum up, there is no uniform rule in establishing whether or not, under the set of given circumstances, good faith is present. A transaction entered into by a director on behalf of the company, which is outside of the purpose from which the company is established, may be considered to be entered in bad faith, depending on the circumstances. Okay, this is all about our presentation for the case Whitehouse versus Carlton Hotel Private Limited. Thank you for watching the video.